My name is Charles Bogert. I'm the new chairman of the Federalist Society. And today we've got a very exciting event going on. We've got Professor Steve McAllister, also Solicitor General of the state of Kansas, and Professor Corey Young here speaking about the future of the Supreme Court. Merrick Garland obviously haven't been nominated and potentially getting confirmed. We'll see how the Republicans react. But the event should be an interesting one. We'll have some time for Q&A at the end, but why don't we just go ahead and get right into it. So Professor McAllister.
Okay, thanks. Well, I think what we're going to do is take a few minutes each to talk about what we think may happen with the court, with just Justice Scalia's passing and a new justice at some point coming on board, and then a lot of time for questions and discussion. So I thought I'd start by saying what I might view as process changes with the absence of Justice Scalia, and then more substantive. And by process, I mean a couple things. And one relates to substance, but I do think at least two things. With only 8 justices and without him, I think what you're going to see in cases granted cert in the next several months is pretty much boring, uninteresting stuff. I don't think they're going to take big cases without him there, and I also think there may be certain kinds of cases they're less likely to take without him there, and some of those would maybe some of the criminal procedure cases, confrontation clause, the jury trial rights, Apprendi and sentencing and so forth. Just because those were things Justice Scalia was very interested in and certainly seemed to be the driving force behind them. With him gone, I'm not sure if the rest of the court will continue to push in those areas. Another procedural aspect that has already perhaps changed, and I think will continue to be true, is oral arguments. There was nobody like Justice Scalia at oral arguments. When I was a law clerk, he had been on the court only about 3 terms, but what he came to was a court that was relatively quiet. It wasn't silent, but there were a number of justices, Blackmun, Marshall, Brennan, who hardly ever said anything at oral argument. Justice White and Rehnquist might ask a few pointed questions, but when Scalia arrived, he jumped right in, and he would question both sides about anything. I think he loved to ask questions and just tweak people. I mean, sometimes you knew he agreed with the person he was arguing with, but he was just testing them. Other times he would jump in and help lawyers when they weren't doing as well as he thought they should on the side he favored. But it's going to be different now with him not there. So one respect is just that he's not there in the middle of every argument. I don't think I ever saw an argument where he did not speak. But I think it is also going to cause Justice Thomas to use his voice. He's already done that once, and I think he'll feel more need to do that. You know, one of the things he would say is, look, any question I might ask, somebody will ask, and I just don't think the lawyers get enough chance to talk. Well, with Justice Scalia gone, I think Justice Thomas will ask more questions, and that may be interesting to see how that affects the dynamic of the court. The other one who might ask similar questions would be Alito, but he's not a real aggressive questioner, actually. So I think Thomas will actually step up. And so just in terms of the dynamic of the courtroom, it's going to feel a little different. Substantively, I was just trying to walk through the Bill of Rights, basically, as my starting point in thinking about where Scalia's absence might make a difference. And First Amendment speech, I doubt it. You know, the court as a whole is very protective of speech. Alito is the only one, really, who will sometimes peel off and say government should be able to prohibit crush videos where people kill small animals for their sexual gratification, or, you know, you could be prosecuted for lying about winning the Medal of Honor. I mean, Alito's the only one who's been at all sort of willing to back up the government. Even in the Phelps case, he was the only one who said maybe you could have a jury verdict against the Phelpses for intentional infliction of emotional distress for their protests at a funeral. So Scalia is much like, you know, the liberal conservative across the board. They're pretty protective of free speech rights, so I don't see any difference there, really, no matter who's nominated. Religion, I do think there's a difference, but it's kind of interesting. It might be both potentially in free exercise and establishment clause. What's interesting there is Scalia is the author of Employment Division versus Smith, which is the big free exercise case. It says if you have a general law, it applies to everybody, no exceptions for religious interests. There are both conservative and more liberal justices who think that's wrong And so a new person who comes on, if they do not agree with Smith, you might see some revival protecting religious objectors under the free exercise clause, because I think it's a close balance. Establishment clause, my guess would be the next justice will be less receptive to mixing religion in the public life than Scalia was. He really didn't have much problem with official prayers and a lot of acknowledgement of religion and so forth. A new justice who's, quote, more liberal in perspective may be stronger on enforcing the lines between church and state. A big one, I think, is the Second Amendment. DC versus Heller was a 5-4 with Scalia writing. I don't think the four that were against him and against that case are strongly against that case, and so a new justice that does not favor gun rights could actually turn the court back. I don't know if they would overrule Heller, but they certainly could try to narrow it and not extend it. Where Scalia was perhaps most interesting in some ways, I think, was criminal procedure, which is Professor Young's bailiwick, not mine. But Scalia, was not necessarily a vote for the prosecution in all criminal cases. It depended on what was going on. There are Fourth Amendment cases where he thought the framers would not have allowed this or thought this was a lawful, legitimate search, so he votes in favor of the defendant. You can't use infrared technology to basically see what's heat that's emanating from a house. You can't use the GPS tracker on the car. It was a trespass for the police to attach it. He was, with some frequency, a vote for the criminal defendant, true in confrontation clause and Apprendi sentencing and jury trial determinations as well. Where his absence could make a big difference, I think, is the death penalty, because there are four who certainly are not crazy about the death penalty. And for many years, there have been 5 who were pretty willing to smack down, in particular, the Ninth Circuit, if it was overturning death sentences in federal habeas review. Now you may have 5 who are quite inclined to overturn death sentences. I'm not saying there will be 5 to outlaw the death penalty yet, but I do think there may become 5 who find lots of reasons that death sentences are erroneous or mistakes were made and they can be overturned. So as a state lawyer, that's not good news probably for me. Another one that he was on the state side was 11th Amendment immunity, so the immunity of the states. That's often a 5-4 issue, and a new justice may not think the states need that immunity, so I won't be surprised if our protection, as you will, under the 11th Amendment takes some steps back with the new justice, whoever that may be. And certainly there's some cases in that line that might well be overruled with a replacement for Justice Scalia. Yeah, and I don't know, in abortion, privacy, family, marriage, he was certainly a strong voice for this isn't in the Constitution, it's not the court's business, we should leave it to the democratic process. He said that over and over and over again. But the fact of the matter is he was usually saying that in dissent. So replacing him may result in a less eloquent writer objecting, but it probably strengthens and will strengthen a majority to protect abortion rights and marriage rights and other things. So I don't think it'll change the direction of the court. It will simply strengthen the majority on those issues. And the last 2 things I thought I'd comment on just briefly. Scalia loved the separation of powers. I mean, that was territory that he just loved to work in. When he teaches, that's what he teaches in his own unique way. But separation of powers he believed in. He was a strong proponent of various ways of keeping the branches separate, not letting the president overstep or Congress overstep. I don't know that his absence, it might or might not change the outcome of cases in that regard, but he had strong opinions, well written, that really articulated some sort of fundamental principles in separation of powers that I'm not sure there'll be a voice like that going forward. So that one also could be a replacement who would have much less concern about in policing the division of powers in the federal government. The last thing I'll talk about is federalism generally. I don't think Scalia was necessarily a huge fan of federalism. What he was a huge fan of was the democratic process and the people deciding important issues. I never had the sense that he was terribly interested in being overly protective of the states as states. He did come to our side on 11th Amendment immunity after first expressing some doubts. And you know, you could say in same-sex marriage that he's arguing for federalism, but I don't know that he really was. He's arguing more, this isn't in the Constitution, it's not the court's job, it should be left to the democratic process. Because one thing that's true of Justice Scalia, probably an area where I had my least success with him as an advocate, was arguing against federal preemption of state law. And he didn't have much qualms about finding that federal law preempted state law in many circumstances. So, you know, there, I'm not sure a replacement will make a lot of difference either. So if I just sum up quickly and turn it over to Corey, it could make a big difference. The next person on religion, both free exercise and establishment clause, could make a very big difference on Second Amendment and how that proceeds going forward. Some criminal procedure territory, his absence and a replacement could make a difference. Death penalty, it will make a difference. And probably state immunity, it will make a difference. Abortion and speech, probably not, other than you'll have, you know, another voice on the majority side of those issues, but it won't really change outcomes. So.
I structured my talk here a little bit differently in that, you know, one of the things that evaluating what a post-Scalia Supreme Court looks like is really just a reflection of what you thought of Scalia and his legacy. And that's something that's still very difficult, I think, for a lot of us to pin down. And there's a lot of contrary views about his legacy. And yet, I want to say it's very similar to what Professor McAllister said, that you shouldn't expect any real sea changes just because there's a new justice on board. And so the first thing I want to do is, instead of looking at the doctrine, is just the similarity of our justices. I had an old colleague who wrote an article called The Stepford Justices in 2007, which is just basically how similar all our justices are in terms of, you know, they go to Harvard and Yale. Many of them are academics, right? 4 of the 9. 8 of the 9 served the federal government in some capacity as a lawyer. Appellate judges, right? All but 1, Kagan, and the DC Circuit in particular, 5 of the 9. What you'll notice, and you'll notice maybe my favorite justice being somebody who focuses on criminal justice, is Sotomayor, because she's the only trial judge we have, and she did both an appellate level and a trial judge appointee. And she actually did some criminal defense work. It's remarkable how little of that there has been in the recent decades for the Supreme Court, given that that's such an enormous part of their docket. And one of the interesting things is Sotomayor was really only countered by Scalia in terms of sort of opposing camps, pro-government, anti-government, but Scalia wasn't consistently so. And I do think Scalia's death will create a void when it comes to criminal procedure and criminal justice. I'm not sure who will speak on behalf of, say, the more conservative justices, because when Alito's done it, he doesn't always get a majority, and he sometimes has much stronger views on issues that don't necessarily connect well with other justices. Thomas, his concern about federalism often cuts in different ways when it comes to criminal justice. Kennedy, it's not clear he's ever really had a coherent view in criminal justice issues. And Roberts, I still can't make sense of sometimes. I'll talk about a Roberts opinion a bit later. And so, you know, Garland fits very well. I mean, he's basically Breyer and Roberts, right?